The Telecommunications and Other Legislation Assistance and Access Act 2018, more commonly known as TOLA, is more than 200 pages long. It is a blisteringly complex piece of legislation, which, in conjunction with a few other factors, has contributed to the mythology of the Act. Now, because it's so blisteringly complex, you are getting 3 parts to this video. Originally, it was going to be one video. It was quickly apparent that it needed to be split up into at least 2 parts, and the original version of this part was more than half an hour long. I swear to God, it nearly killed me. It was so boring. This video will give you a policy context for the TOLA so that you know what the debate is about. Now, in the second video, I'm going to give you a breakdown of the content of TOLA so that you know what's in it. And in part 3, I situate TOLA within the broader context of national security and surveillance law using the slogan, "Trust but verify." Nothing in this area of law is an isolated discrete unit. It is a complex network of law. And this approach that I've taken here is driven by one of my philosophical bugbears. The public needs details in order to have specific, grounded, evidence-based discussions. But it also needs those details to be situated in the right context so that we can develop the right legal intuitions. Okay, there is a lot of mythology about the TOLA, and in my view, a lot of this mythology is a reasonable reaction to the way that TOLA became law. We know that the government undertook very narrow and targeted consultation prior to releasing the exposure draft of the bill on the 14th of August 2018. Already at that stage, it was a long and difficult piece of legislation. You would have expected a lengthy time for stakeholders to digest the issues. Instead, submissions about the exposure draft were due within a month, by the 10th of September 2018. And then, less than a fortnight later, the bill was introduced into Parliament. Again, you would have expected a lengthy period of time for the relevant parliamentary committees to consider the bill in detail. Instead, it was pushed very quickly through the Parliamentary Joint Committee on Intelligence and Security, the main parliamentary forum for considering national security issues. The bill was passed by both houses of Parliament on the 6th of December, a bit over 2 months after being introduced. 2 months is not normal. In comparison, the Telecommunications and Other Legislation Act from 2017 took about 11 months to go through the legislative process. So let's be really, really clear at the outset. If the government wanted a more informed discussion about TOLA, it probably could have done more to inform the wider debate. Now, on the other hand, we know that we didn't have the luxury of time. Operation Trojan Shield, the FBI's sting operation using a messaging app called Anom, had already begun. And, as we'll see in the other video, Australia's legislative restraint on the national intelligence community is a lot more strict than in other countries. What can our national intelligence agencies do without legislative authority? If they do something that is not neatly on statutory footing, will that infect prosecutions later on down the track? And most importantly of all, what happens if you're dealing with entirely new partners in the fight against security threats? Quickly, for the sake of clarity, Operation Trojan Shield was the FBI's name for the operation. The Australian Federal Police called it Operation Ironside. And in this video, I refer to this operation because I don't know the legal technicalities of Operation Trojan Shield. I also mentioned the Parliamentary Joint Committee on Intelligence and Security. The parliamentary bit of the name means that it's made up of politicians. It's not an expert committee or a body made up of appointed outsiders. The members of this committee are elected parliamentarians. Now, joint means that it's made up of both senators and members of the House of Representatives. 5 senators, 6 members. And the intelligence and security bit means that it has an oversight role of the national intelligence community, which I'm not entirely sure you can see clearly there. But some of these people you probably know. So the Australian Security Intelligence Organisation is ASIO. That's probably the most well-known. Maybe you've heard of the Australian Secret Intelligence Service, which is ASIS. Not all of these agencies fit within the PJCIS's scope, and some of these agencies only partially fit within its scope. A bit more on this issue is in the third video. Now, I've recently seen it published in the media that the PJCIS is a bipartisan committee. This isn't strictly accurate. The PJCIS has 11 members, the majority of whom must be government members, and there is no requirement for all members of the PJCIS to agree with its recommendations. For example, the PJCIS's report on the impact of the exercise of law enforcement and intelligence powers on the freedom of the press had additional comments from the Labor members of the committee, and they said, look, the committee's recommendations simply don't go far enough. The ALP gets a fair amount of criticism for its bipartisan position on national security issues, and TOLA is a very good example of that criticism. The ALP members of the PJCIS fairly successfully used the committee as a way to shape and amend legislation. It was through the PJCIS process that the government agreed that there would be 2 post-enactment reviews of TOLA. One of these would be a full PJCIS review of the Act in order to make up for the fact that it had gone so quickly through the committee prior to enactment. And the second one would be done by the Independent National Security Legislation Monitor, who appears very prominently in my third video. The ALP submitted additional comments to the PJCIS report saying, in effect, that they were uncomfortable with the rush, but understood that there was some urgency to the legislation, and therefore they were willing to support the legislation being enacted if they got these detailed and comprehensive reviews. It was, in my opinion, a very good way of balancing 2 competing needs, but you are always going to get slammed by this final image of the ALP voting on the same side as the coalition, while the crossbench get to point to themselves in the picture and say, look at us, we're the only ones who stand up for civil liberties against the spectre of the police state and Hydra and the Illuminati and all the other threats to your personal right to commit the cool crimes. Okay, way less editorializing now. Let's set up the policy context of TOLA. Imagine that you're a rogue back in the 1970s and you want to communicate with other rogues. Your options are fairly limited. Importantly, your major forms of communication are over networks that belong to the state. Over the past half-century, technological innovation has been about moving larger amounts of information faster and further. What a miracle of technology it is that I can now fall out of a plane in the middle of the outback and get out my phone and still have enough reception to access WOOKIEEPEDIA, the largest online database of Star Wars facts. We often think about national security legislation eroding our privacy, but this isn't strictly true. In a lot of situations, legislation is about maintaining the current balance between security and privacy. In the 1990s, if you wanted to intercept a telephone communication, you put alligator clips on the line. In the 2000s, if you wanted to intercept the same message, you needed new powers to intercept mobile phone transmissions. And in the 2000s, if you wanted to intercept the same message again, you needed new powers to access sound files that are sent via the messaging apps of private companies. It's exactly the same balance between privacy and security, but you need to run flat out updating your surveillance powers just to stay in the same spot. Today, we face the problem called going dark. People know that agencies have the ability to access messages on some platforms, and so they move to platforms where they think agencies have less ability to intercept them. Necessarily, agencies are always a step or two behind technological development. That was a very tricky sentence. TOLA was a response to the proliferation of encrypted technologies that made it harder to access communications. Let's walk through this. Here we have Harley Quinn and Poison Ivy, two rogues who regularly collaborate on dastardly deeds. We have some intelligence that says that they are very likely to be planning something awful. Can authorities intercept the messages sent between them? Well, we know the answer. If we are back in the 1990s and they are using a telephone like this, authorities might be able to intercept a message. Right? Now, let time progress until we've got to the old Nokia phone. Same message between the same rogues with the same background facts. Should the fact that the technology has changed affect the authorities' ability to intercept a message? Now, most ordinary people say no, but if you look at this strictly through giving more powers to authorities lens, which most of our media does, then you're going to end up with a slightly different intuition. Strictly, they can now access communications that they couldn't before, messages sent using a technology that did not previously exist. But also accessing these communications might give you more information about the people communicating than was available previously. If you were using a landline telephone, authorities knew your location. It was with the phone. Now you take the phone where you go and broadcast that information when you communicate. Harley might have been somewhere that she shouldn't have been, for example, or somewhere embarrassing, or somewhere that she might just wanted to have kept private. And we go through the same reasoning process with the apps. Should the fact that technology has changed mean that authorities can no longer access the same message? Normal people say no, but again, think about how much more information apps broadcast about us when we communicate. That's what we mean by this. A lot of this area of law is just about maintaining the status quo. TOLA, largely, was about maintaining the status quo. Encryption was proliferating, people were going dark, legislation was needed to preserve the existing powers. That is it for this one. I'm under 15 minutes, so I'm really, really happy. If all of this makes sense so far, the next video will be something of a breeze. Fire off any questions you might have to me over on Twitter @LegalReckoning, and I will see you in part 2. Bye-bye.